This video is being brought to you by Boundless Enterprise LLC in association with Las Vegas Nevada DUI.com. That is www.lasvegasnevadadui.com. This is the Las Vegas DUI discussion, and today the topic is, are checkpoints constitutional? In a word, checkpoints are not constitutional. And the point about it is that you have a freedom of travel. So, if that's the case, they do not have a constitutional right to arbitrarily stop you. I'm going to go into the discussion of your constitutional freedom to travel. Freedom of movement under United States law is governed primarily by the Privileges and Immunity Clause of the United States Constitution, which states, "The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states." As far back as the Circuit Court ruling in Corfield versus Coriel, 6 Fed Case 546 in 1823, the Supreme Court recognized freedom of movement as a fundamental constitutional right. In Paul versus Virginia, 75 U.S. 168 in the year 1869, the court defined freedom of movement as right of free ingress into other states and egress from them. However, the Supreme Court did not invest the federal government with the authority to protect freedom of movement. Under the Privileges and Immunities Clause, this authority was given to the states, a position the court held consistently through the years in cases such as Ward versus Maryland, 79 U.S. 418 in the year 1871, the Slaughterhouse cases, 83 U.S. 36 in the year 1873, and United States versus Harris, 106 U.S. 629 in the year 1883. As early as the Articles of Confederation, the Congress recognized freedom of movement, Article 4. Though the right was thought to be so fundamental during the drafting of the Constitution as not needing explicit enumeration. You have to understand that in those days it would be unthinkable for the government to stop a person from being able to travel. I will point out to you what a DUI checkpoint does to you, how it stops you from your freedom. In the United States versus Wheeler, 254, U.S. 281 in the year 1920, the Supreme Court reiterated its position that the Constitution did not grant the federal government the power to protect freedom of movement. However, Wheeler had a significant impact in other ways. For many years, the roots of the Constitution's Privileges and Immunities Clause had only vaguely been determined. In 1823, the Circuit Court in Corfield had provided a list of the rights, some fundamental, some not, which the clause could cover. The Wheeler Court dramatically changed this. It was the first to locate the right to travel in the Privileges and Immunity Clause, providing the right with a specific guarantee of constitutional protection. By reasoning that the clause derived from Article 4 of the Articles of Confederation, the decision suggested a narrower set of rights than those enumerated in Corfield, but also more clearly defined those rights as absolutely fundamental. But the Supreme Court began rejecting Wheeler's reasoning within a few years. Finally, the United States versus Guest, 383 U.S. 745, in the year 1966, the Supreme Court overruled Chief Justice White's conclusion that the federal government could protect the right to travel only against state infringement. The 1910 Mann Act, White Slave Traffic Act, it's not something you hear every day, among other things, banned the interstate transport of females for otherwise undefined immoral purposes, which were taken to include consensual extramarital sex. This act was used, in addition to less controversial cases, to allow federal prosecution of unmarried couples who had, for some reason, come to the attention of the authorities, such as interracial couples, which was illegal. Ergo, boxer Jack Johnson and people with left-wing views, ergo Charlie Chaplin, were prosecuted. The act remains in force as of 2010, but with added safeguards against abuse. The Supreme Court also dealt with the right to travel in the cases of Sands versus Roe, 526 U.S. 489 in the year 1999. In that case, Justice John Paul Stevens, writing for the majority, held that the United States Constitution protected three separate aspects of the right to travel among the states: the right to enter one state and leave another, the right to be treated as a welcome visitor rather than a hostile stranger, protected by the Privileges and Immunity Clause in Article 4, Section 2, and for those who became permanent residents of a state, the right to be treated equally to native-born citizens. This is protected by the 14th Amendment Citizenship Clause. In discussing are checkpoints constitutional, in doing my research, a lot of people feel that the police are the ultimate authority. They don't understand the role of the police. The police actually are not an authority. They are simply armed guards. They have no constitutional authority. They have no state authority. The only thing is that they capture you, arrest you, and incarcerate you. That is the only aspect of their job. The people that actually have authority are the district attorney, the legislature, the governors, the presidents, and the actual courts. When people look at police, they are trying to equate the police to our military, which goes and tries to protect us, which of course in the 19th and 20th and 21st century, they are no longer protecting the United States. They're protecting the corporate interest. I ran into a lot of discussion about people saying, well, if you were to turn away from a checkpoint and the police come after you, people responded to that with, if you run away from a checkpoint, then you are guilty, and that the police have every conceivable right to come and arrest you on face value. That is possibly the most ignorant and dangerous thinking out there. The police don't have an authority to arrest you, and that is not probable cause to arrest you. That is not probable cause to or proof of anything. Many people think that flight is some sort of admission of guilt. Flight is no more an admission of guilt than fleeing from a snake. People flee from snakes and lions because they fear snakes and lions. People flee from police because police shoot people and kill people constantly, every day. We need to understand that in a situation on the ground, in the actual moment, flight is not an admission of anything other than that you are afraid of confronting what is in front of you. You have a constitutional right to freedom. This constitutional right to freedom in a DUI checkpoint means that the DUI checkpoint itself is illegal, because if you have a right to stop, that means that you have been arrested automatically. Stopping you means that you have been arrested. People do not understand what the word arrested means. Stopping you is arresting you. The illegal stop and frisk in New York means that the police are arresting people left and right without probable cause. I want to keep this completely short and to the point, that DUI checkpoints are unconstitutional. It doesn't mean that states haven't put into law that DUI checkpoints are constitutional. It's just that nobody has challenged the constitutionality and won. That's it. Thank you for watching. This has been a Boundless Enterprise production. Thank you.